In the investment world, when a key insider provides sworn testimony in open court that directly contradicts a company's public representations and that establishes facts the company had fought vigorously to conceal, it represents something far more consequential than ordinary witness testimony. It signals that someone with intimate knowledge of internal operations has concluded that their own legal jeopardy or moral obligations require telling the truth under oath, regardless of how that truth damages the enterprise they were part of building. That is exactly where we are right now with what emerged from a federal courtroom this morning when Ivanka Trump provided testimony that legal observers are describing as potentially decisive in multiple cases against her father. Testimony that reportedly sent Donald Trump into a fury, and that has immediate implications for both his legal defense strategy and his already fractured family relationships. Before we proceed, if you find this kind of comprehensive analysis valuable, please take a moment to like this video and subscribe to the channel. It helps us continue providing the detailed coverage that examines these developments beyond the sensational headlines and provides the business and legal context necessary to understand their full significance. From an investor's perspective, this is not merely another dramatic moment in an ongoing legal saga. This is about understanding what drives someone to provide testimony that contradicts their own father's interests despite the obvious personal costs involved. What the specific content of that testimony reveals about facts that are crucial to multiple prosecutions, how courts and juries are likely to evaluate testimony from someone whose credibility is enhanced by the personal sacrifice involved in providing it, and what the existence of such testimony means for the viability of legal defenses that depended on maintaining different narratives about key events and Trump's knowledge of their legality. What we are witnessing matters to anyone concerned about how family loyalty intersects with legal obligations, about the weight courts give to insider testimony that comes at personal cost to the witness, and about what happens when carefully constructed legal defenses collapse because key witnesses decide that truth under oath takes precedence over protecting family members. Courtroom testimony from family members against defendants does not occur through casual decisions or through coercion that would undermine its credibility. It happens when individuals face legal compulsion to testify truthfully, when they conclude that their own legal exposure requires cooperation rather than evasion, or when they determine that moral or civic obligations override family loyalty in circumstances involving serious alleged misconduct. And that is what I want to talk to you about today, because Ivanka Trump's courtroom statement carries implications that extend well beyond its immediate impact on specific legal proceedings and speaks to deeper questions about the limits of family privilege. The moment when self-preservation or principle requires breaking from family interests, and what happens when the most credible possible witness provides testimony that undermines fundamental elements of a defendant's case. In my 94 years, I have watched how insider testimony shapes outcomes in complex legal proceedings, how witnesses who have obvious incentives to support defendants, but who nonetheless provide damaging testimony, are viewed as particularly credible precisely because they testify against their apparent interests, and how such testimony often proves decisive in cases where other evidence might be disputed or ambiguous, but where insider accounts provide clarity that juries find compelling. As someone who has spent over half a century analyzing how information from inside organizations affects legal and financial outcomes, how credibility assessments drive jury verdicts in cases involving disputed facts, and how legal strategies adapt or collapse when key assumptions about what witnesses will say prove incorrect, I can tell you this. When a defendant's own daughter provides sworn testimony in open court that establishes facts the defendant has denied that contradicts key elements of his defense strategy and that aligns with prosecution theories about criminal conduct and intent, it represents extraordinary evidentiary development that fundamentally alters the landscape of all related proceedings. Such testimony carries weight far beyond what external witnesses can provide because family members are presumed to have both detailed knowledge and powerful incentives to protect rather than damage their relatives. Markets teach you that when insiders with comprehensive knowledge provide information that damages their own interests and relationships, that information should be given substantial credence because the costs of providing it suggest the witness believes accuracy and legal obligation override other considerations. Family member testimony against defendants operates on similar principles. The personal and relational Costs are so high that courts and juries generally conclude such testimony must be truthful because the witness would have powerful reasons to shade or withhold information if accuracy permitted doing so. Now, I am not here to express satisfaction at family conflict or to speculate about Ivanka Trump's personal motivations beyond what can be reasonably inferred from the legal context. Let me be clear about something. From where I sit, this is about understanding what compelled Ivanka to provide this testimony when she had previously sought to avoid testifying at all. What the specific content of her courtroom statement establishes about facts that are contested in multiple cases, how her testimony interacts with other evidence to create comprehensive record that prosecutors can use, and what the existence of this testimony means for Trump's legal position going forward, given that his own daughter has now established under oath facts he has consistently denied. What happened this morning in the federal courthouse in Washington represents more than just another day of trial testimony in what has been a long and complex proceeding. It represents a moment when the defendant's closest family member, someone who worked alongside him in business and in the White House, someone who has every personal reason to want to protect him, provided testimony under oath that prosecutors are describing as confirming the core elements of their case regarding his knowledge, intent, and deliberate violations of law. According to reporters who were present in the courtroom, and according to transcripts that are now being made public, Ivanka Trump testified for approximately 4 hours this morning in the federal election interference case. She was called as a prosecution witness after efforts to quash her subpoena were exhausted and after she unsuccessfully argued that her testimony should be limited based on claims of privilege or irrelevance. Her testimony delivered in response to detailed questioning from prosecutors and under oath with potential perjury consequences for false statements addressed several key areas that have been subjects of dispute in multiple cases against her father. First, Ivanka testified about conversations she had with her father in the weeks following the 2020 election, in which he explicitly acknowledged to her that his fraud claims lacked factual foundation, but stated that he was using those claims strategically to maintain political support and to create pressure on officials who were certifying election results. This testimony directly contradicts Trump's central defense in the election interference case, which is rested on his assertion that he genuinely believed the election was stolen and that his actions reflected good faith efforts to address fraud rather than knowing use of false claims to obstruct legitimate governmental processes. Ivanka's testimony that he acknowledged to her the claims were false but politically useful establishes criminal intent in ways that prosecutors had struggled to prove definitively through other evidence. Second, Ivanka testified about her father's handling of classified documents after leaving the White House, describing conversations in which he acknowledged that he was not supposed to retain the materials, but stated that he wanted to keep certain documents because they related to matters he considered important for his legacy or for future political activities. She described observing him directing staff to move boxes of materials at times that she now understands, corresponded to periods when his attorneys were attempting to account for classified materials in response to subpoenas. Her testimony establishes that Trump knew he was required to return the documents, that he deliberately retained them despite that knowledge, and that he took active steps to conceal them from investigators. All elements that are crucial to proving willful retention and obstruction charges in the classified documents case. Third, Ivanka testified about business practices at the Trump Organization during periods when she served as executive vice president, describing her father's personal involvement in decisions about financial reporting and asset valuations that are at issue in civil fraud cases. She confirmed that he was directly aware of discrepancies between valuations used for different purposes and that he made deliberate decisions about how to characterize assets based on what would be most advantageous in particular contexts, rather than based on consistent application evaluation methodologies. Her testimony corroborates prosecution theories that Trump knowingly provided false financial information for improper purposes. Rather than making good faith errors or relying on professional advice. Fourth, and perhaps most significantly from a strategic perspective, Ivanka testified about her father's state of mind and his approach to legal and ethical constraints more generally. She described him stating on multiple occasions that rules and laws were obstacles to be circumvented when they conflicted with his objectives, and that his position and resources meant he could usually avoid consequences for actions that would subject others to liability. This testimony goes to his general intent and consciousness of wrongdoing in ways that help prosecutors establish that his conduct across multiple alleged violations reflected deliberate disregard for legal requirements rather than mistakes or misunderstandings. What makes Ivanka's courtroom statement particularly devastating is not any single element of testimony, but rather how the combination establishes a comprehensive pattern of Trump's knowing violations of law across multiple contexts, confirmed by someone who is present for key conversations and events and whose credibility is enhanced by the obvious personal cost she incurs by providing testimony that damages her father. Prosecutors have other evidence supporting their theories in each case, but much of that evidence is circumstantial or comes from witnesses whose credibility Trump's attorneys can attack based on bias or limited knowledge. Ivanka's testimony provides direct evidence from someone who cannot plausibly be characterized as biased against Trump and who demonstrably had detailed knowledge of relevant facts because of her intimate involvement in both his business operations and his political activities. The immediate reaction in the courtroom when Ivanka completed her testimony reflected the significance that both sides understood her statement carried. Prosecutors appeared satisfied and relieved, recognizing that they had obtained testimony establishing facts they had struggled to prove conclusively through other means. Trump's legal team appeared stunned and deflated, understanding that their client's own daughter had undermined key elements of defense strategy they had been developing across multiple cases. The judge presiding over the trial made notation suggesting the testimony would factor significantly in her evaluation of the evidence. Most tellingly, Trump himself, who had been present in the courtroom, left immediately after Ivanka finished testifying, departing through a side exit without making his usual comments to assembled media. His subsequent statements through social media and through spokespersons have been notably vitriolic, attacking Ivanka personally and suggesting she was coerced or confused in her testimony. Attacks that legal experts suggest may backfire by drawing additional attention to testimony that is likely already highly credible to jurors given the source. What has happened in the hours since Ivanka's testimony concluded extends beyond just the immediate courtroom. Impact to include broader responses from legal experts, political observers, and other parties involved in various Trump-related proceedings. Legal analysts across ideological spectrum have characterized the testimony as potentially decisive, noting that family member testimony establishing criminal intent and knowledge is precisely the kind of evidence that proves most persuasive to juries because it is difficult to explain away and because it comes from a source whose incentives run against providing damaging information. Several former prosecutors have stated that if they were leading Trump's defense team, they would be urgently exploring plea negotiations because the combination of Ivanka's testimony with other evidence makes conviction at trial highly probable. Political strategists have noted that the testimony further undermines Trump's electability by confirming for moderate voters that the legal cases against him have substantial evidentiary support rather than being politically motivated persecution. The convergence between Ivanka's courtroom statement and the various other challenges Trump faces creates conditions where each problem compounds the others in ways that make his overall situation increasingly untenable. Her testimony provides evidentiary support for criminal prosecutions that were already proceeding based on other evidence, but that now have been strengthened substantially. The fact that his own daughter felt compelled to provide this testimony despite the family split, it reinforces the narrative that even those closest to him recognize his conduct was indefensible. The testimony provides ammunition for civil cases and for creditors seeking to collect judgments by establishing Trump's knowing participation in fraudulent practices. Most fundamentally, it eliminates one of his last remaining strategic advantages, the hope that key witnesses would refuse to provide damaging testimony or would testify in ways that created reasonable doubt about his knowledge and intent. Let me walk you through why family member testimony is viewed as particularly powerful in criminal proceedings and why Ivanka's specific testimony this morning is likely to prove especially significant. Juries are instructed to evaluate witness credibility by considering factors including bias, knowledge, and consistency with other evidence. Family members testifying against defendants would typically be viewed with some skepticism based on potential bias. But in cases where family members provide testimony damaging to defendants rather than supporting them, the bias consideration actually enhances rather than undermines credibility. Jurors understand that family members have powerful reasons to protect relatives and that providing testimony that harms family members therefore suggests the witness believes accuracy and legal obligation override family loyalty. This creates presumption of truthfulness that is difficult for defense attorneys to overcome. In Ivanka's case, several factors enhance her credibility beyond the general principles about family. Testimony. She has no apparent legal exposure herself that might motivate cooperation to obtain favorable treatment from prosecutors. Her testimony came only after her subpoena was upheld through multiple court challenges, suggesting she testified reluctantly due to legal compulsion rather than voluntarily due to any agenda against her father. Her testimony was specific and detailed rather than vague or qualified, indicating clear recollection of relevant events. Her testimony was consistent with documentary evidence and with testimony from other witnesses who lack the credibility advantages she possesses. Her testimony addressed facts within her direct personal knowledge rather than being based on hearsay or speculation. The combination of these factors makes her testimony extraordinarily difficult to impeach through cross-examination or through defense presentation of contradictory evidence. Additional reporting and legal analysis in the hours since the testimony is focused on how Trump's legal team will attempt to respond and whether there are viable strategies for minimizing the damage her testimony has caused to their cases. According to legal experts familiar with the proceedings, Trump's attorneys face extremely difficult choices. They can attempt to impeach Ivanka's credibility by suggesting she was confused, coerced, or biased against her father. But such attacks risk alienating jurors who are unlikely to believe that his own daughter would falsely testify against him and who may react negatively to attempts to attack a witness who appears to be testifying truthfully despite personal costs. They can attempt to reframe her testimony by arguing it establishes less than prosecutors claim. But the specificity of her statements about conversations in which Trump acknowledged his fraud claims were false and his documents retention was improper makes reframing difficult. They can attempt to minimize importance of her testimony by arguing that other evidence creates reasonable doubt. But when the defendant's own daughter confirms prosecution theories about knowledge and intent, creating reasonable doubt becomes substantially more difficult. Regardless of what other evidence suggests, the most likely strategic response, according to experienced criminal defense attorneys observing the case, would be to explore plea negotiations while there is still time to obtain some concessions from prosecutors in exchange for guilty pleas to juries. Prosecutors who obtain testimony this strong typically have less incentive to offer favorable plea terms because they are confident of convictions at trial, but they may still prefer plea agreements that guarantee convictions and avoid trial risks and delays. The question becomes whether Trump's personality and his political calculations permit him to accept plea agreements, even when doing so might be his least bad option from a pure legal risk perspective. To be clear, Ivanka's testimony, while highly significant, does not by itself guarantee Trump's conviction in any particular case or eliminate all possible defenses he might offer. Juries remain unpredictable, and even compelling testimony from credible witnesses does not ensure guilty verdicts if defense can create sufficient doubt through other means or if jurors engage in nullification based on their political views. However, the testimony fundamentally shifts the burden in ways that make Trump's conviction substantially more probable in cases that go to trial. Prosecutors who had been carrying burden of proving knowledge and intent beyond reasonable doubt through circumstantial evidence now have direct testimony from highly credible insider witness establishing those elements explicitly. That transformation of the evidentiary landscape has obvious implications for outcomes. The pattern we are seeing with Ivanka's testimony fits into broader trajectory of Trump's legal position deteriorating as more insiders provide testimony or evidence contradicting his public narratives and establishing facts he has denied. Over time, we have seen testimony from senior administration officials, from attorneys who represented him, from business associates who worked with him, and from his wife describing his private acknowledgments about various matters. Each additional insider witness makes his claims of innocence less plausible and makes prosecution theories more credible. Ivanka's testimony represents the most significant insider evidence yet because of her relationship to Trump and because of the specificity with which she has confirmed elements that prosecutors needed to prove but had struggled to establish definitively through other evidence. The push from prosecutors to obtain Ivanka's testimony, despite her resistance and despite the obvious complications it creates within Trump's family, reflects their judgment that her evidence was crucial enough to justify the extraordinary effort involved in compelling family member testimony. Federal prosecutors generally avoid seeking testimony from defendants' close family members unless the evidence such witnesses can provide is essential to proving the case, and unless prosecutors are confident the testimony will be truthful and material. The fact that prosecutors invested months in litigation to compel Ivanka's testimony, and the fact that they questioned her extensively in court this morning about specific conversations and events, indicates they believe she possessed unique knowledge that was necessary to prove critical elements of their cases. The testimony she provided appears to have met those expectations by establishing facts that no other witness could confirm with equal credibility. Historical context provides some perspective on how family member testimony affects major criminal cases and why such testimony often proves decisive when defendants have relied on claims that their conduct reflected innocent mistakes or good faith misunderstandings rather than knowing violations. In organized crime prosecutions, testimony from defendants' family members who participated in criminal enterprises has frequently provided evidence defendants' knowledge and intent that prosecutors could not obtain through other means. In white-collar fraud cases, testimony from family members who worked in family businesses has established defendants' awareness of fraudulent schemes and their personal direction of illegal activities. In political corruption cases, testimony from defendants' relatives has confirmed that allegedly improper payments or activities were known to defendants and were undertaken deliberately rather than through subordinates' unauthorized actions. In each context, the family relationship enhances rather than undermines credibility when testimony damages rather than supports defendants. And juries typically give such testimony substantial weight in reaching verdicts. What makes Ivanka's testimony potentially comparable to historically significant family testimony in other major cases is the combination of her credibility, the directness of her knowledge about key facts, and the importance of what she has established to prosecution theories across multiple cases. If her testimony proves as influential as early assessments suggest it may be, it will rank among the most significant insider testimony in cases involving major political figures, comparable to testimony from John Dean during Watergate or testimony from Oliver North during Iran-Contra in terms of its impact on public understanding and on legal outcomes. We are not neutral observers watching courtroom proceedings unfold as entertainment divorced from real consequences. We are all stakeholders in whether family relationships create testimonial privileges that prevent full truth from emerging in legal proceedings, or whether legal compulsion can overcome family loyalty when testimony is material to serious charges. We are stakeholders in how courts and juries evaluate testimony that comes at obvious personal cost to witnesses, particularly when such testimony contradicts defendants' public narratives and establishes facts defendants have fought to conceal, whether we are concerned about legal accountability, about institutional integrity, or about practical questions of how justice systems function when defendants have used family enterprises to conduct alleged criminal activity. These dynamics affect our understanding fundamentally. When family members provide testimony establishing defendants' criminal knowledge and intent despite powerful personal reasons to protect those defendants, it demonstrates that legal compulsion and oath requirements can function even in circumstances involving the strongest possible conflicting loyalties. At its core, Ivanka's courtroom statement represents a moment when legal obligation and perhaps personal conscience overcame family loyalty in circumstances involving serious allegations of criminal conduct. Can family members be compelled to testify against defendants in ways that provide crucial evidence of guilt? Yes. When privileges do not apply and when their testimony is material to contested issues. Can such testimony prove decisive in determining outcomes despite defendants' claims of innocence? Yes. When testimony comes from credible sources with direct knowledge and when it establishes facts that defendants cannot plausibly dispute. Can defendants maintain defense strategies premised on claims that their conduct was innocent when their own family members testify under oath that defendants acknowledge wrongdoing? No, because juries are unlikely to believe that family members would falsely testify about such admissions given the personal costs involved in providing testimony that damages close relatives. What happens in coming weeks and months as Trump's legal team attempts to manage the fallout from Ivanka's testimony and as the various cases incorporating her evidence proceed toward resolution, will determine whether her courtroom statement proves as consequential as initial assessments suggest. If Trump's attorneys can successfully minimize the impact through effective cross-examination or through presentation of contradictory evidence, the testimony may prove less decisive than prosecutors hope. If plea negotiations occur and result in agreements that avoid trials where the testimony would be presented to juries, its ultimate impact will be in shaping settlement terms rather than in producing trial convictions. However, if cases proceed to trial with Ivanka's testimony as centerpiece of prosecution's evidence regarding knowledge and intent, the testimony is likely to prove extremely difficult for defense to overcome given its source and its specificity. The landscape continues evolving as Trump responds to his daughter's testimony, as his legal team recalibrates strategy across multiple cases to account for evidence they had hoped would not be presented in this form. As other potential witnesses reconsider their own positions about cooperation after seeing that even Trump's daughter concluded she had legal obligation to testify truthfully, and as prosecutors incorporate Ivanka's testimony into their trial preparations and potentially use it to pressure additional cooperation from other witnesses who recognize that prosecution has obtained highly credible evidence establishing key facts. In coming days, we will likely see additional legal motions addressing how Ivanka's testimony affects various proceedings. Additional reporting about Trump's personal reaction and about implications for family relationships already damaged by recent splits. Polling data showing whether voters' assessments of Trump's legal situation change based on testimony from his daughter, and strategic decisions by Trump's remaining supporters about whether testimony from this source affects their evaluation of the cases against him. We should maintain perspective that while Ivanka's testimony is highly significant, it does not guarantee specific outcomes or eliminate all uncertainty about how cases will resolve. Trials remain complex processes where multiple factors affect verdicts beyond any single piece of evidence. Juries can be unpredictable even when prosecution presents compelling cases. Appeals and procedural challenges can affect ultimate outcomes, regardless of trial results. However, the direction of impact is clear, even if magnitude remains somewhat uncertain. Ivanka's testimony substantially increases probability of conviction in cases where it is relevant by providing direct evidence from highly credible source about facts that are essential to proving guilt and that defendants had previously been able to contest through claims that witnesses lacked knowledge or had biases affecting their testimony. Whatever ultimately transpires, Ivanka's courtroom statement will be studied as significant moment in understanding how insider testimony shapes outcomes in cases involving powerful defendants who have used family relationships and enterprises to conduct activities that become subjects of criminal investigation. How prosecutors obtain testimony despite defendants' attempts to prevent it through privilege claims. What the testimony established about contested facts regarding knowledge and intent. How credibility was evaluated by courts and potentially by juries, given the family relationship and the personal cost to the witness, and what impact the testimony had on ultimate case outcomes will all provide important lessons about the role of family member testimony in complex criminal proceedings. We are participants in this moment when legal proceedings against a former president have reached stage where his own daughter has provided testimony potentially decisive to multiple prosecutions. We are stakeholders in whether family relationships limit accountability or whether legal systems can compel truthful testimony, even from those closest to defendants, when such testimony is material to serious charges. The choice is being made by prosecutors about how to use this testimony, by defense attorneys about how to respond to it, by judges about what weight to give it in evaluating evidence, and ultimately by juries if cases reach trial about whether to credit it will shape outcomes, with implications extending beyond Trump's individual cases to affect broader understanding of how family member testimony functions in criminal justice system. I have witnessed 94 years of American legal proceedings, including major cases where insider testimony proved decisive. When witnesses with intimate knowledge of alleged criminal conduct provide testimony, establishing defendants' awareness and intent despite personal costs involved in testifying against family members or close associates. Such testimony typically carries substantial weight because courts and juries understand that the sacrifices involved in providing such testimony suggest credibility that external witnesses lack. Ivanka's testimony this morning appears to fall into that category of potentially decisive insider evidence. Testimony that establishes facts defendants cannot plausibly dispute, and that makes their claims of innocence substantially more difficult to maintain. This moment feels significant because it represents a defendant's own daughter providing sworn testimony in open court that directly contradicts his core defense theories and that establishes facts prosecutors had struggled to prove conclusively through other evidence. If testimony from this source with this content proves as influential as experienced observer expected, may mark the point at which Trump's legal defenses across multiple cases became effectively untenable, regardless of how aggressive his attorneys remain in contesting charges and in attacking prosecution theories. The existence of such testimony from such a source fundamentally changes the landscape of all related proceedings by eliminating defendants' ability to claim that evidence of knowledge and intent is speculative or circumstantial. So pay attention to how Trump's legal proceedings evolve in light of this testimony as cases approach trial or as plea negotiations potentially accelerate based on changed assessment of trial risks. Watch whether defense strategies adapt in ways that acknowledge the damage this testimony has caused, or whether Trump insists on approaches that do not account for evidentiary realities. Observe how other witnesses potentially respond to seeing that even Trump's daughter concluded legal obligation required truthful testimony despite personal costs. Note whether public perceptions shift based on testimony from source whose credibility is difficult to dispute and whose knowledge is unquestionable. Understand that insider testimony establishing criminal knowledge and intent represents the most powerful evidence prosecutors can obtain in cases where defendants claim their conduct was innocent. Remember that when family members testify against defendants under oath, despite obvious reasons, to protect rather than damage their relatives, courts and juries generally conclude such testimony must be truthful because the costs of providing it are so high. If you found this analysis valuable in understanding what Ivanka's courtroom testimony means for Trump's legal position and for broader questions about family member testimony in criminal proceedings, please take a moment to like this video and subscribe to the channel. Share this with others who want to move beyond sensational headlines to understand substantive legal implications of major developments. These are important questions about how legal systems compel truthful testimony, even from those closest to defendants, and about whether such testimony proves decisive when it establishes facts that defendants have contested throughout proceedings. The answers emerging from these cases will inform legal practice and public understanding for years to come. Thank you for your time and attention to these critical matters.